Hello there, I'm attorney Kelly Longtin, and this video is talking about and focusing on whether a domestic partner has the same rights as a spouse when it comes to estate planning. And the short answer to whether couples in a domestic partnership have the same rights as married couples when it comes to estate planning is probably not. And to a large extent, the state in which you live, and maybe even the city or the county, determines domestic partners' rights. Let's first talk about what is a domestic partnership. So everyone knows what a marriage is, but not everyone really knows or understands what a domestic partnership is. And to answer whether domestic partners have the same estate planning rights as married spouses, it is helpful to first define what a domestic partnership is. Now, a domestic partnership is an alternative to marriage that was originally created for same-sex couples who could not legally marry. However, when the U.S. Supreme Court legalized same-sex marriage in 2015 in the Obergefell versus Hodges case, a marriage became an option for same-sex couples as well. A domestic partnership is not just for same-sex couples. Any couple can choose this status when marriage is not something they desire for whatever reason that is. In general, a domestic partnership is a relationship in which two adults live together and plan to do so indefinitely. They each may intend to remain the other's only domestic partner, may be financially responsible for each other, and may or may not enter into a legal agreement defining their rights and responsibilities. In fact, the laws on domestic partnerships and the legal rights and benefits domestic partners receive vary widely by state. Now, most states offer no domestic partnership benefits. The remaining states offer either full domestic partnership benefits or fall somewhere in between. So examples of some of these types of benefits are health insurance, sick leave, parental leave, death benefits, the power to make financial and medical decisions on their partner's behalf, and also adoption rights. Now, some states that offer domestic partnership benefits require that the couple formally register in order to receive them, and other states do not require that formal registration. And as a result, it is essential to understand your state's laws when determining the benefits that a domestic partner may have. Now that we've defined what a domestic partnership is, it is essential to understand the estate planning issues that unmarried couples face, including those who are not in a valid domestic partnership recognized by local law. Now, every state has default rules that address what happens to a person's property upon their death, or who can make decisions for a person who is incapacitated and cannot make decisions for themselves. Now, for married people, the default person is usually a spouse, but problems can arise if your significant other is not a legally recognized spouse. Now, being unable to manage your significant other's financial affairs or speak with institutions or government agencies on their behalf if they become incapacitated. And that's if your partner hasn't set up a financial power of attorney, naming you as their agent authorized to act on their behalf, then a court will have to appoint someone as a guardian or conservator to manage their affairs. Now, if there's no spouse, state default laws usually give priority to either a child, a parent, or another relative when they are deciding who to appoint as a guardian or the conservator. Now, being unable to make medical decisions for your significant other, or to visit them in a hospital, or obtain healthcare information about them during a serious illness or an incapacity, and this is if your partner has not set up a healthcare power of attorney and a living will or an advance directive, then there's default laws that specify who is authorized to make those decisions and receive medical information. And that's, again, usually going to be a child or a parent or a grandchild or a grandparent if there's no spouse involved. Now, there can also be the potential of losing out on income or government benefits or perhaps insurance benefits and retirement benefits that are exclusive just to a deceased person's surviving spouse, but are not in existence for domestic partners. Also, as domestic partners, you're going to have to pay more in federal estate or gift taxes because there's no marital deduction or exemption for unmarried couples. There's also a loss of opportunity of being able to take advantage of a tax deferral by rolling over retirement accounts because they can be rolled over only by the deceased account owner's surviving spouse. And as domestic partners, if you don't have an estate plan in place, you may not be able to serve as the executor or the personal representative of your deceased partner's estate if your partner has not created that will or a trust and named you to serve in that role. So if a person dies without a will or a trust, state default laws usually provide that a surviving spouse or a child or another relative has priority to serve in that role. Also, there's the risk of losing property or accounts after your significant other's death if your name was not on the title of that account. And then there's the frightening possibility of losing custody of your children if you're not their legal parent, either through adoption or a legal proceeding giving you parental rights. As I've touched upon, unmarried couples face a number of estate planning issues. So depending on your state and to the extent to which your state's law recognize domestic partnerships, some of these potential benefits may still be available to you as an unmarried person in a domestic partnership. Other benefits, however, such as benefits under a federal estate and gift tax laws or retirement account laws, are only available to married couples. Because domestic partnership laws vary so widely, it is important to consult with an experienced estate planning attorney in your area who can help you understand the laws that apply to your situation and the estate planning you must do to ensure that your significant other will have the rights and the benefits that you want them to have if you become incapacitated and upon your death. So we're available to help you with an estate plan if you're in a domestic partnership and you need help clearly specifying your wishes for your loved ones about your money and property. So regardless of the relationship, the legal relationship between you and your partner. So if you live in Massachusetts or New Hampshire, we're happy to help. Otherwise, I hope you found this video to be educational and help you with your estate planning needs. I'm attorney Kelly Longtin, founder of Kelly Longtin Law, and I just want to thank you all for watching.